developing gender-neutral laws for harassment. Today, we'll be building on that foundation, diving into the intricacies of the POSH Act 2013, and we'll be discussing its relevance and application in creating safe work environments. So before we begin, let me briefly go over some housekeeping notes. Today's session will also run for approximately an hour. As with yesterday, there will be a Q&A session at the end. Feel free to drop your questions in the chat box throughout the presentation, and we'll be addressing them at the end. The session will be recorded, and we will be sharing it you after the session. And I urge you all to please keep your microphones muted during the presentation to avoid any distractions. Once again, I am pleased to introduce our speaker, Advocate Sakshi Kothari. Sakshi ma'am is a distinguished advocate at the Madhya Pradesh High Court and serves as an assistant professor at Indore Institute of Law with a BBA LLB from Amity University and LLM in International Trade and Investment from Gujarat Maritime University. Sakshi ma'am has an extensive experience in both legal practice and academia. She has participated in numerous seminars and training programs where she shares her insights on gender neutral laws, among other topics. We are grateful to have you, ma'am, for the today's session. Thank you once again for joining us. The virtual floor is yours, ma'am. Over to you.
Thank you so much. So, today we will be having an engaging session because in between I have also made some type of situations in which the audience will be answering to it that whether it will be amounting to the sexual harassment or not. So, firstly, let us begin with the structure of today's presentation. The phase 1 we will be discussing about the Vishaka guidelines. The phase 2 will be the key definitions which are given under the POSH Act, sexual harassment of the workplace. Phase 3 are the key obligations of the employer, what is the procedure, redressal under the IPC as well as the POSH Act. And phase 4 is how we can create and safe working environment in our offices, organizations. So the first we are starting with our Vishaka case. Though yesterday we discussed about in the 1997 the Vishaka cases came into existence, in which the facts were that there was a woman named Bhavri Devi who was brutally gang raped. Why was she brutally gang raped? Because she was working in an NGO as a social activist, and she went to nearby a village in Rajasthan to ban a child marriage. So while she went over there, so she faced such type of a brutal gang rape by the political influential persons. Though she was not aware about that work, the place where she was being visiting, so she visited alone. So she was being brutally gang raped. Further, the Supreme under the Supreme Court, there was a writ petition filed by the social activist and the NGO for the enforcement of their fundamental rights under the Article number 40, 19, and 21 of our Constitution, prevailing that these are the violation of these rights which are not uncommon. Though she was brutally gang raped, so this was the aim for the attention towards the social aberration and assisting the finding suitable methods for realizing the concept of gender equality. So further, the Supreme Court used the opportunity to address that where are the lacunas or the loopholes that we have been facing in our laws for the women workers in our country. What can be the remedy from any of the sexual harassment at any of the workplace? So further, we have been discussing about the Vishaka guidelines, which came into an enforcement for the prohibition, prevention, and redressal of the sexual harassment for the women at the workplace. So, firstly, the guideline was been talking about the duty of the employer and other responsible persons who have been working in the workplaces or other. Second, there was been scope of widening of the scope of sexual harassment, in which we also included any other unwelcome physical, verbal, or the non-verbal conduct of the sexual nature. Thirdly, they discussed about the preventive steps that all the persons who are in charge of that workplace, whether in the public or the private sector, has to take an appropriate steps to prevent the sexual harassment. Fourthly, the criminal proceedings that we will be discussing, like under the IPC, how we can deal it, or under the POSH Act, how we can deal it. In particular, it is ensuring that the victim or the witnesses who have been witnessing such type of an issue has to deal with the complainant mechanism of the sexual harassment, should also have an option to seek transfer of the perpetrator or their own transfer. Fifth guideline was relating to the disciplinary action. If there is such type of a misconduct in the employment prescribed in our relevant services rule, then the appropriate disciplinary action should be initiated by the employer in accordance to those rules. Sixth guideline was relating to the complainant mechanism for filing the complaint, right? And seventh one relating to the composition and the constitution of a complainant committee, in which we will be dealing that if an organization is having more than 10 employees, then the institution has to constitute the complainant committee and maintenance of the confidentiality clause into it. Eighth is a worker initiative that all the employees should be allowed to raise their issues of the sexual harassment at the workers' meeting in the appropriate forum, and it should be affirmatively discussed in the employer as well as the employee meeting. Ninth, we are talking about the awareness that has to be spread in each and every workplace regarding the rights of the female employees in the suitable manner. So these were the key major guidelines which were discussed under the Vishaka guidelines, named at unincorporated with the same definition of sexual harassment and the procedure as which has been laid out in the Vishaka guidelines. Now we are understanding the objective of a POSH Act. The first objective is to preventing and protecting the women from any of the workplace. Like yesterday, we discussed about the United Nations Convention on Elimination of All Forms of Discrimination Against the Women, the UN Convention, in which the India is also signatory to it. And though the objective has been created from this itself to affirm that all the state parties have to take the appropriate measures to eliminate all forms of discrimination against the government. Second is to ensure an effective redressal of the complaint of sexual harassment. If any of the women has been facing such type of an harassment in their workplaces, then how can they address, under what fundamental rights they can go, or under which sections of the POSH Act they can claim that yes, this was happened to us and this has been also been including in this provisions. So these were the main objectives that were given under the POSH Act. Now we are talking about the definitions clauses under the POSH Act. The first, we are talking about the sexual harassment. These are the circumstances in which we have been relating it to the sexual harassment, like if any implied or explicit promise of the preferential treatment in the employment. Like yesterday, we discussed about the situation like a quid pro quo, that in an harassment there should be two main ingredients. First is the quid pro quo and second is the hostile or a toxic environment. So considering the example that a male employee has been working and a female employee is working under him and he is asking for a sexual favors from a female employee. So these are considered the circumstances in which we are considering it to in sexual harassment, like any implied or explicit promise of the preferential treatment, threat of detrimental treatment of the employment, threat about the present or the future employment status. Like in that scenario, it was like that if the woman has been sleeping, so she's thinking about a future employment status. That if I am been sleeping with that man, then he might get me a promotion. Also, in such cases, he might not get a promotion to that woman, right? So it is present or future employment status, which can be either implied or an explicit. Interference with the work of creating or intimidating or a hostile environment. Humiliating treatment likely to affect the health or the safety of that person or woman working in that organization. So these are the circumstances in which we have been including the sexual harassment. Second, we are talking about the act of the sexual harassment, which can be any unwelcome acts of the behavior which is directly or by the implication. First is the physical contact in the advances. If a woman has been coming up with any of the physical contact with any of the male person, right? And the male person is forcing or just trying to trouble that woman, so it will be coming under our physical contact. Second is demand or request for the sexual favors. Third is talking about the making sexually colored remarks. Means you are not being calling a person by its own name or making some type of a sexually colored remarks to that person, which is not making him discomfort in that shared space, right? Showing pornography, like yesterday we discussed about that if there is any other shared space and we have been sharing a pornography among our peer groups. So this is also an act of sexual harassment which will be amounting. Any of the unwelcome physical, verbal or the non-verbal conduct of the sexual nature. So yesterday we discussed about the verbal, non-verbal conduct. So this is the addition. While if we read the BNS section number 75, which is talking about the sexual harassment, you won't find the unwelcome physical, verbal or the non-verbal conduct of the sexual nature. Though it has been added in a POSH Act after the Vishaka case came into an existence. Now, this is a situation. I will request all the participants to read through this situation and let me know that whether it is constituting to the sexual harassment or not. Yes, anyone?
Guys, please unmute and share your thoughts. We would love to see this session to be interactive. Anyone, please? You may use the chat box if you're not comfortable in unmuting yourself. Purna Sloka says it is not a sexual harassment. Vijay says it is a sexual harassment. Ma'am, are you able to see the chat box, right?
No, I'm not able to see because I'm sharing my screen.
Okay, okay. So should I read it for you?
Yeah, sure. Thank you.
Okay, so Purna Sloka says, in her opinion, it is not sexual harassment. I mean, you are also supposed to give the reasons, right?
Right.
Jignesh is saying that this won't be considered as sexual harassment because it is in compliance of some work which is allotted.
So they both are correctly stating that yes, this situation is not amounting to the sexual harassment because instead of Miss B, there might be any of the other person who would be incompetent to work in as with the team leader, right? If a team leader is using a harsh language, you will not be constituting it as a sexual harassment because as we already read about the act of the sexual harassment, which is such type of an implied or explicit talking about the present or the future employment status or detrimental to the treatment of the employment, right? So these are not the situations that we have been considering for a sexual harassment. But the harsh language, if Mr. A is using the harsh language with any of the other, right? If a boss is shouting on you, will not be amounting to the sexual harassment because he wanted work to be done on the time before the deadline it reaches, right? So over here, if Miss B is feeling embarrassment for filing the case for an sexual harassment against the Mr. A, that the report was only to harass her, so she can't file because instead of her there might be any of the other person also. But the team leader is always considering the another person who is working with him or her is considering to be incompetent enough to work in that report. So yes, the harsh language will never be constituting to the sexual harassment. Though if it would be some type of an obscene material or an obscene content would be there in that language, will be amounting to the sexual harassment. But if a boss is shouting on you, will not be amounting to the sexual harassment. Now we are talking about the workplace, which is including any of the private organizations, such as any organization or the person who has been visiting, arising out, or during the course of the employment. A workplace
Sorry
would
for
be.
interruption, ma'am.
Yes.
Manthan Kurmi says it is not sexual harassment as there was no physical intent of A to harm B. Is there any relevance of physical harm here?
No, in that case, we are not considering that there was a physical harm to that woman, Miss B. So that's why it was not amounting to the sexual harassment. But if we consider if there is any physical harm to that woman, that like a Mr. A was coming closer to him, or while they were working, the Mr. A thought to remove the chair of that woman, right? So these might be the acts which will be amounting. But in that situation, it was not because they were only asking that the language that the Mr. A has used, will that be amounting to the sexual harassment or not? Though it was in harsh language, while we are getting frustrated, so we might take out a frustration to any of the other employees, right? As a team leader, you have so many responsibility to be done before the deadline reaches. So in that case, it is not amounting to the sexual harassment because there was no physical contact, or there was no any sexually colored remarks being made for that Miss B, or there were not any pornographic content over there, or there were not any implied or explicit preferential treatment among both of them. So that's why this situation is not amounting to the sexual harassment. But if there might be any physical contact, so yes, then it will be amounting to the sexual harassment. Now we're talking about the workplace, which could be any place where a working or a professional relationship is existing. The colleagues, peers, employee, employer, team leader, or the team members will all be constituting to the workplaces. Though yesterday we discussed about the extended workplace, like if the organization is organizing any dinner party, so yes, this will be mounting to the extended workplace. If in that party, if something happens, then we can say that yes, this is amounting to a sexual harassment because there was somewhat physical contact in that party, right? Now this is situation two. You can let me know that whether it is amounting to the sexual harassment or not.
It would be great if you people can unmute and have your opinions presented. Okay, ma'am, we have got four responses, and all of them are saying that yes, it does constitute sexual harassment.
So yes, this situation is considering to be sexual harassment at the workplace, because when you're working in an organization from 9 to 5, in that place you are not being in the contact of the information with any other person, because you have any work to be done at that point of time. But after 5 p.m. you are being considering to taking the employee's number, having sharing the social medias with them. But having sharing social media is okay, but cracking somewhat obscene jokes and the memes will be amounting to the sexual harassment. Though we studied about the cyber harassment, so it will be coming under an ambit of a cyber harassment, because it was being digitally happening to that woman, right? So she might also face such type of an psychological harassment from that, or emotional. She might not have a fear of retaliation to talk to anyone. She might be isolating from the peer groups, right? So in this case, yes, this is amounting to the sexual harassment, because there has been a cracking of an obscene jokes in the memes to that woman during not the working hours but after the working hours, because the employee as well as the employer is working and having a professional relationship existence in that. So yes, this situation is amounting to the sexual harassment. Now we have been talking about the key obligations of the employer. The key obligations of the employer is: first one, to promote a gender sensitivity at the workplace, remove the factors creating an hostile working environment, providing a safe working environment, formulating and widely disseminating an internal policy for the prohibition, prevention and redressal of the sexual harassment at the workplace, displaying conspicuously at the workplace the penal consequences of indulging the acts that may constitute to the sexual harassment, declaring the names and contact details of all the members of the internal committee. So these are the obligations that are to be followed by the employer, to have to promote a gender sensitivity in our workplaces, that there should be no an hostile working environment, having unsafe working places, in that internal policy about the prohibition, prevention and redressal of the sexual harassment should be given to each and every employees working in that organization. What are the penal consequences if someone is filing any false or frivolous complaint against any of the person in that organization, declaring the names and the details of the internal committee, like if there is a senior most female employee working over there, then who is she. So these all should be reported to all the employees who have been working in that organization, so that the employee is also aware that where he or she has to go to file a complaint regarding the sexual harassment. Organizing workshops and the awareness programs, providing assistance to the woman if she chooses to file a complaint, treat sexual harassment as a misconduct under the service rule and initiate the action for the misconduct, monitor and timely submissions of the report by the internal committee, publish the statistics of the complaint under the POSH Act in the annual report of the company. Means to make an aware about the POSH in your organization for the employees' welfare. So we have to organize a workshop. Secondly, if the woman is not able to write a written consent relating to the POSH policy, then how can she file a complaint in that regard? Thirdly, if we have been treating as a sexual harassment as a misconduct, so which is also governed in our services rules of a POSH Act. Fourthly, we are talking about the monetary timely submission of the report. Like if you can see this example of an extract which is taken from a Tata Steel, From the year 2017 to 2018, there has been a disclosure clause in this, which is saying that there has been zero tolerance towards the sexual harassment, in which 24 complaints of the sexual harassment, out of which 16 have been resolved by the appropriate actions and 8 are under the investigation procedure. So these type of disclosures are to be disclosed by each and every organizations or any of the workplaces which have been working, so that the people are also aware about that the reputation of this organization, that how many such type of complainants are there under it, with the line with the provisions of a POSH Act, and how the compliances report have been prepared. Each and every yearly report have been prepared for the POSH, that if there is no sexual harassment in that workplace, then you have to mention that there was the no. But in case if there is any, then they have to mention like this, that during the year the company received 24 complaints, out of which the 16 were being resolved and 8 are under the investigation. Now the person who has been facing such type of an harassment, to whom he should report the complaint. Apart from the internal committee, the management, supervision or the controlling management is there. If we talk about the management, the person discharging the contractual obligation with respect to the employees, person, board, committee responsible for the formulation of the policy. The one who is formulating the policy is also responsible if there is such type of an issue that have been faced in that organization by the employees, then they have to come to that person with the, acting as a supervisor or acting as a controlling management. Like they, every time they can't reach to the HR professional that we have faced such type of sexual harassment, we are coming up with you. No, there is a chain of hierarchy of the people that we have to follow. If we go to the management, or we go to the supervision, or we go to the controlling authority. Now we are studying about the consequences which are given under the POSH Act. The first is the punishment which are prescribed under the service rules of the organization. Second, we are talking about withholding of any promotion, increment, that the committee can also decide the termination of the employment. If there is a perpetrator who has been found in that organization causing a sexual harassment to the other employees, then these are the consequences of the punishment which are prescribed under the POSH Act. First one, we are following the services rule. Second is, if the person is having such type of a promotion of the increment, may also terminate the employment depending on the decision of the committee. Fourth is, like there might be also deduction in their compensation of the wages which are to be provided to that employee. In case if there is any false or malicious complaint be filed, then the company can also take a disciplinary action against it by not suspending that person, but may impose a penalty on it as prescribed under our services rule. Now we are talking about the IPC provisions which have been dealing. First one is outraging the modesty of the woman, 354, like an assault or a use of a criminal force to any woman, intending to outrage or knowingly to outrage her modesty, which is punishable for the 5 years and shall also be liable for the fine. But under our BNS New Criminal Bill 2023, the section number 76 has been dealing with this. Now, if we talk about the sexual harassment by a man, which has been described under the section number 75 of our BNS 2023, physical contact advances, demand or request for the sexual favor, showing pornography, making sexually colored remarks. Now, under the IPC provision, there has not been a mentioning any unwelcome acts of the verbal, physical, or the non-verbal conduct, right? But in our POSH Act, there has been an addition to this section in the definition clauses, that we are also talking about any unwelcome acts which are causing such type of a physical, verbal, or the non-verbal conduct, which is also punishable for the 3 years and shall also be liable for the fine. Now, if we talk about the stalking, which has been described under 78 of our BNS 2023, which might be also talking about in cyber stalking, following a woman or contacting or attempting to contact such women despite a clear indication of disinterest, monitors the use of the woman of internet, email, or any other form of electronic communication, so which is also punishable for the 3 years and shall also be liable for the fine. Now, if we talk about insulting the modesty of the woman, under our BNS 2023, section number 79 is talking about it. The whether if there is any sound, gesture, or exhibiting any object with an intent to insult her modesty will also be amount to such insulting the woman's modesty and amounting for the simple imprisonment up to 3 years and shall also be liable for the fine. Whether is there an action or a behavior, if both of them are being present, then also it will be amounting. If one of them is also present, then also it will be amounting for insulting the modesty of the woman. Now this is the situation. Let me know whether this is amounting to the sexual harassment or not.
And we have got 13 responses in total so far, and all of them are saying that yes, it does amount to sexual harassment. Manthan Kurmi says yes, it does amount to sexual harassment because A, being under the influence of alcohol, tried harassing her.
So yes, this is amounting to the sexual harassment because there was a dinner party being thrown by the colleague. But in this, can we include an extended workplace because it was in colleague party? So in that, there might be a group of 4 to 5 people who would be having their own drinks or something like that. So yes, this is amounting to the sexual harassment because in this we are being considering that a colleague has invited all the employees as well as the employer as well as the CEO of the company into that. So in this we are considering that yes, there was an official notice given by that organization that you all have been invited, and considering that there was some sexual harassment being caused because the woman or that person was coming up closer to him, closer to her, or making some type of an physical contact, right? So yes, this is amounting to the sexual harassment, but in this we can also take in defense of intoxication, that a person was already drunk, in drunk situation he did something like that. So whether it will be said to be in sexual harassment or not. So in this case, it will be amounting to in sexual harassment. We are not being considering the defenses of intoxication in this case. Now in this we are discussing about the procedure of the complaint mechanism. The first one is that who can file a complaint. The aggrieved woman can file a complaint in writing to the concerned committee within the period of 3 months. When a woman has been facing such type of a sexual harassment in that any workplace or any of the organization, so she can file a complaint within the 3 months of her incident. Considering it to be a physical incapacity of that woman, then any of the relative, friend, co-worker, National Commission for the Women or State Women's Commission or having a knowledge or the one who has witnesses that incident will also be can also write a complaint on behalf of an aggrieved woman with the written consent of that aggrieved woman. If the consent has been given by the aggrieved woman that so and so person will be filing a complaint on behalf of me, then only the complaint will be considered. Secondly, if the woman has been in the mental incapacity that she cannot tell the what she has been faced at that moment of time, so that's why we are considering a qualified psychiatrist or a psychologist or a special educator. Because if a person is not able to express herself the what was the situation happened to her, then a psychiatrist or a psychologist will able to understand her mind or a feeling that she might be facing. So yes, even if she write a written consent, then only they can file a complaint against any of the perpetrator working in that organization, or if the perpetrator is not from that organization or outside, then also a written consent has been required from an aggrieved woman. Then only the complaint can be filed. Now this is the last situation. In this situation, there is the two questions that can Miss B file a complaint on behalf of Miss B or not. Second is whether the Mr. A is amounting to a sexual harassment in this case or not. Miss B.
Jignesh Bhanushali says, yes, ma'am. Miss C can file complaint against Mr. A, and it amounts to sexual harassment. Khushi Mishra also supports the argument. Purna Sloka says, I think it is sexual harassment, but Miss C cannot file complaint because she does not have the consent.
So in this situation, the first is talking about that is Miss C allowed to file a complaint on behalf of Miss B, who is an aggrieved woman in this case. If there has been a written consent given by the Miss B, then she is allowed to write a complaint. Miss C is allowed to write a complaint only when the written consent has been given by Miss B. Second, yes, the conduct has been amounting to this sexual harassment because he has been insisting and not creating a professional relationship with her, and we are being considering that the sending her emails would having some type of an obscenity in that. So yes, if this is also the case, then we are considering it to be sexual harassment. So this is a situation of a sexual harassment, and first one answer is that Miss C can only file a complaint on behalf of Miss B when the Miss B has given a written consent. If Miss B is not providing a written consent, then the complaint cannot be filed by the Miss C for Mr. A. Now we are talking about the confidentiality clause. The first is content of the complaint, the identity and address of the complainant, respondent and the witnesses, any information relating to the inquiry proceedings, recommendations of the committee and the action taken by the management to the public, press or the media in any of the manner. Means when a situation comes of a sexual harassment in any of the organization, so we have to keep it confidential because we can't disclose it to the media. Yes, we have gotten sexual harassment because it might be also defaming our organization, right? Will harming our organization's reputation. So we can't do that. We have to disseminate all these information in the confidential. The confidentiality clauses containing these all three things. First is the content of the complaint. Second is the identity and the address of the complainant respondent. And third is any of the information till the time it has not been resolved, it has to be kept to be confidential till the inquiry procedure. Now we are talking about the constitution of an internal committee. The first is each and every organization who is having more than 10 employees have to set up an internal committee. The one will be the presiding officer with the minimum of 3 members, including the presiding officer at the present of conducting the inquiry. Not less than 2 members committing to cause of women involved in social work and having a legal knowledge. 1 member from any NGO or committed to cause of women with a familiar with the sexual harassment cases. So if an organization is having more than 10 employees working in that organization, they have to set up an internal committee having a presiding officer. Under him there might be 3 members. First, 1 member can be from an NGO or a social activist who have been dealing with the sexual harassment cases. 2 other members will be considered to be legal advisor who has been involved in that social work or having a legal knowledge that what all policy that we can formulate and how can these cases be resolved under which provisions and which way of provision we have to file the cases for the sexual harassment. So that's why we are considering the 2 legal advisors, one from the NGO and one is the presiding officer. Now we are considering the procedure of the complaint mechanism. First is when the incident of a sexual harassment take place, then it goes to the internal committee or the local committee of that organization. Report of the inquiry. If there has been no action taken by the employer, then it goes to an appeal to the court or the tribunal. If in case there has been any in the middle of our inquiry procedure, we get to know that the complaint was being filed false or frivolous in nature, then we are considering it to directly go to an appeal of the court. And if in case in between we find that if the action is for the misconduct that we are considering under our services rule under our POSH Act, so then it will directly go to the appeal to the court. In case if we already know the victim and the perpetrator are already in our organization, right? Then we set up a conciliation between both of them. Like the conciliation officer is acting as a third party representative in it, that without the biasness he's making ensuring that the justice has been served for the victim or the perpetrator. He doesn't know or he's not a member in that internal committee. He has been called from outside as a conciliation officer and has to settle the matter without the inquiry procedure has been set up. Most of the cases in the conciliation procedure, it always goes when the organization already know that this complaint has been false or malicious in nature, or having frivolously filed against any of the men, right? So that's why most of the cases are being resolved by the conciliation method only. But if the victim has not been satisfied by the conciliation, what all the judgment or what all the suggestions were be given by that conciliation officer, then further they go for the inquiry procedure, then they go for the appeal to the court or the tribunal. Now we are talking about the 10 ways to know that your office has been safe. That having an anti-sexual harassment policy, the policy is easily accessible and periodically updated. Sexual harassment is a misconduct under the service rule. A functional redressal committee has to be established in each and every workplace of the organization. Presiding officer of any of the internal committee acting as a senior female member. Like if we already studied about a constitution of our internal complaining committee, the presiding officer is always a senior female member. And when we are talking about the committee members, who are from one from the NGO and two others are from any of the legal advisor acting in the legal capacity of a sexual harassment cases. They might be a man or a woman. It is not constituting that a woman will only be set up in an internal committee. There might be a man or a woman there in that committee. If there is a third party representative on the committee, as we mentioned about the conciliation officer, which is acting as a third party representative in it. Educate information on the internal committee members, its role and redressal procedures are being displayed prominently. All the complainants are being received in writing. If someone is unable to do so, then the committee's members help them to write. Even nowadays, with the help of a digital tools, the HR professionals are creating such type of a platform that we can file our online complaint. So, if the woman is also unable to file an online complaint, then there has been a assistance to be provided to that woman by the internal committee itself. That this is the platform that where you can file, how to write. So, these are the training and the workshops which are being conducted to know that where the woman can file the complaint. Conducting regular workshops and the training to raise awareness against the sexual harassment at the workplaces. Apart from this, we can also follow the 5 Ds if we see any of a sexual harassment happening in any of our public places, right? So the first one D is talking about directly. When you know that the perpetrator is harming the victim, though you already know that the perpetrator is having a knife in his hand or a gun in his hand, so you can directly approach. But if in case if they don't have any of the weapon with him, or her, then you can directly approach. Second, you can go to and distract. Secondly, you can follow his distract. Like if you are in a public place, you already know that the perpetrator is having a weapon with him, so you can create a destructive situation in that community that the perpetrator doesn't harm to that woman, right? Third is delegate. You know that if I go directly to the perpetrator, it might also harm me. So that why you are using this third D of delegation, that you can call police for the assistance, or if it is happening in your workplace, then you can call the HR that yes, this is a situation happened in this so and so places, and these both are working in our organization. So in this case, you can delegate your work. Fourth one is talking about the delay procedure. Like you already know the victim and the perpetrator are good friends of mine. Why are they having such type of an issue with them? So, but you can't help them at that moment, right? Then afterwards, when your work has been completed, you go to them or you talk to them. So it is creating a delay situation in their cases. Like you know both of them, but what is the main issue happening with them that you really don't know. But after delay has been taken so that you can resolve their issues, right? Fifth D is talking about the document. Though you already all have the smartphones, so you can also record. which would be also considering as an evidence for the sexual harassment which was being taken place in that so and so places. So if you follow these 5 Ds, then you can create a safe and inclusive environment in the workplaces or any of the other places. Direct, distract, delegate, delay, and document. Thank you.
Thank you, ma'am. That was a fantastic overview of the POSH Act and its implication in promoting workplace safety. We are now ready for our Q&A session. If any one of you having any doubts, please move forward and ask your doubts by unmuting yourself. Or you may drop your queries in the chat box.
No queries from the
Okay, so since
participants.
there are
Thank
no
you.
queries, we are wrapping up the session.
Okay, thank you.
Um, Okay, so as we wrap up today's session, I would like to extend our heartfelt gratitude to Advocate Sakshi Kothari, ma'am, on behalf of the entire Legal Quorum family. Ma'am, your expertise and invaluable insights over these past 2 days have truly enriched our understanding. Your guidance on gender neutral frameworks and the POSH Act has been both enlightening and thought provoking, offering us practical perspectives that we can apply in fostering safer and more inclusive workplace environments. Um, we deeply appreciate the time and effort you have dedicated to making this event impactful for all of us. Looking ahead, we hope this is just the beginning of our collaboration. We would love to work together on future events. Once again, thank you, ma'am, for being here with us, and to our participants, thank you all for your active engagement. Together, let's continue advocating for equity, respect, and inclusivity in all spaces. We look forward to connecting with you all again in future events. Thank you all, and have a wonderful day ahead. Also, we have shared the feedback form in chat box, so you all are requested to fill the same. After which, we'll be providing you with the e-certificates. We'll be providing the e-certificates very soon, most probably by tomorrow.